everyone, and welcome to the New Earth Lawyer podcast. My name is Geraldine Johns-Putra. I'm your host. I'm a lawyer based in Melbourne, Australia. I am coming to you from Bunurong country, and I wish to pay my respects to their elders, past, present, and emerging. Today, we're very fortunate to have with us Sarah Dadush. She is with the Rutgers Law School. She writes and teaches in the areas of business and human rights, consumer law, and social enterprise law. As a professor there, her research lies at the intersection of business and human rights, and she's exploring innovative legal mechanisms to improve the social and environmental performance of multinational corporations. And anyone who watches this podcast knows that that's a particular interest of mine. So I'm very excited about talking to Sarah. Before joining the Rutgers faculty, that Sarah also served as a legal counsel and a partnership officer for the International Fund for Agricultural Development. That's a UN agency. She was also a fellow at NYU's Institute for International Law and Justice. And previous to that, she was an attorney at Allen & Overy in New York. She has a JD and an LLM in international and comparative law from Duke University Law School. Sarah, welcome to the New Earth Lawyer podcast.
Thank you so much, Geraldine. It's really nice to be here.
Yeah, we were just chatting. We had a chat last week, actually. And one of the things that we were talking about was the work you're doing now in contracts. So that actually, we've had discussions on this show about contracts before, specifically values-based contracts. So I was really interested to hear what kind of work you're doing in contracts and how that is intersecting with your social enterprise work and your business and human rights work.
Yeah. Well, the project that I'm working on now is with a working group that was formed under the auspices of the American Bar Association's business law section. And it's a working group that was tasked with drafting model contract clauses that firms could include in their international supply contracts, with the goal being to improve the human rights performance of those contracts, and by extension to improve the human rights performance of global supply chains generally. And so there was actually two versions of the model contract clauses. One came out in 2018, and I wasn't involved in the drafting of that one. But I thought there were many, many interesting things about that initiative. And the version 2.0, I was very deeply involved with, and that just came out in like March, April of this year. So, what I think is was extremely interesting about version 1.0 that is still very applicable for version 2.0 is the notion that there are many ways in which it is difficult to hold corporations accountable for bad human rights stuff that happens in their supply chains, in particular when that stuff happens outside of the country in which the corporations are incorporated. And as you know, we don't. So in other words, there is it's difficult for national laws, even that would regulate corporate misconduct, to reach over into stuff that happens overseas. And then we have a deficit in terms of national law and its reach. And we also have a deficit in international law, because international law doesn't really apply to corporations, right? It is, if we think of international law as international treaties, those are entered into by governments, and governments are the the ones who are subject to
Yeah.
the treaty law. So there is a real gap in terms of norms that apply to corporations, conduct in particular, conduct that extends into international waters and lands.
Yeah.
And one of the things that is so powerful, it seems to me, about contracts is that they cross borders. Like they have this power that legislation type hard law doesn't have. And you can use contracts to develop and enforce and institutionalize all kinds of norms that may go above what national law or international law would expect, right?
Yeah, absolutely. I mean, this is exactly the experience we found in Australia. So we had our Modern Slavery Act come in 2019, and what that act does is it requires entities with consolidated revenue of 100 million Australian or more to report on the risks of modern slavery in their operations and supply chains. So their operations can be onshore or offshore, and their supply chains are actually broadly defined so that it'll cover indirect suppliers as well. So it'll actually go to the ultimate supplier in any direction in their supply chains. And so having to report on the risks of modern slavery, which is forced labor, child labor, human trafficking, forced marriage, those all come under the umbrella of our modern slavery definition. Having to report on the risks means having to do a degree of due diligence. And it's purely a reporting requirement. But what has happened is that through that requirement to basically do due diligence, or you can't report meaningfully, the reporting entities had to develop a framework, and of course contracts came into that framework. So we developed in Australia, the legal fraternity developed modern slavery clauses. And in fact, as I shared with you last week, the Commonwealth government, our Australian federal government, put out a model clause that companies, reporting entities can use to require their suppliers to basically be minimizing the risk of modern slavery in their operations and then in their supply chains. So reaching through the mechanism of contract to at least the direct suppliers, and then trying to reach through to the indirect suppliers where a contract doesn't exist, but enforcing it through the chain. And it was a really interesting experience, because what happened was that even companies who were not required to report because they didn't meet the reporting revenue threshold found themselves becoming indirectly bound by the Modern Slavery Act, or indirectly influenced by the Modern Slavery Act, because they had customers who were putting these requirements onto them. So contracts are a very powerful tool, even if they are a private law tool.
Mm-hmm. Yeah. And they're as you put it, I mean, I think part of what you're saying is that contracts are can be identified as a way to come into compliance with national legislation. So national legislators are, it's a good thing for national legislators, especially developing due diligence legislation or any kind of reporting requirements, to include contracts in those laws. And so I do think that contracts have this, this aspect that is helpful for compliance purposes, but sort of more profound to me is that they can be used also to like implement the spirit of the due diligence laws, and to really sort of bring a deeper coherence into being between what companies say that they do to look after human rights in their supply chains and what they actually do to look after human rights in their supply chains. And contracts are a really big part of companies' operational lives, like not just for legal compliance purposes, but also for, well, how are we going to relate to one another, buyer and supplier, and how are we in our relationship going to take the interests of non-parties like workers or the planet into account as we move forward in our own contractual relationship. And a lot of companies, I think, say that they are doing good or want to do good or better, but don't think about, well, what do my contracts say about this? What do my contracts tell me I should be doing in this situation or not doing in this situation? Or how do I not only be in right relationship with my counterpart, but also through my contract in right relationship with non-party stakeholders?
And this is a really interesting point, because I work with companies who are trying to embed purpose and operationalize purpose, because these companies have, they're set up under a structure which is all pointed towards making a profit. That's in the framework. And even if it's not in the DNA of the company, so the company might be set up as a social enterprise, they are working within that legal framework. So I've been looking at work, for example, a British Academy did a report a couple of years ago now on the principles for purposeful business. And they've identified the things within the system that need to change. So they've identified laws, regulations, the objectives of shareholders, the objectives of investors, the metrics, the performance indicators, and the corporate finance. All of those things need to change. But contracts also
and the
need
contracts. What about the contracts?
Yeah. Governance was included in that list. And you could say that within governance is contracts, but you don't make that link automatically. And when you were talking to me last week about that, it's like it was the light bulb moment for me, because I also deal with contracts. I mean, almost which lawyer doesn't? Yeah. At some stage, we're going to be drafting contracts. Even if you're a litigator, you'll be drafting settlement deeds. So it's so powerful. And what a direct way for lawyers to be effecting change within companies trying to be more purposeful.
Mm-hmm. Yeah, it definitely can be, they're like little norm vessels is one way that I like to think about contracts, that sort of carry norms around, and you get to decide what are the norms going to be. Yeah. You have a lot of, freedom of contract is not a joke. You have a lot of discretion, right? In deciding what goes in to your agreement. And if what you want is to, I do think that along these lines of operationalizing purpose, as you say, contracts are a really key ingredient of operationalizing purpose. If you don't bring your contracts in support of your purpose, many contracts, especially supply contracts, where one company that doesn't make stuff is buying stuff from a company that does make stuff. So in the manufacturing industries, if you don't enlist your contract as an ally to advance your purpose, it is likely that your contract will undermine your purpose, because most contracts are drafted very much on a sort of a zero-sum approach, so that and the sort of culture in manufacturing supply agreements, particularly in industries like apparel, right, but also agriculture and also electronics, are such that we kind of have a big power disparity between the buyer and the supplier. the buyer of the stuff and the maker of the stuff.
Mm-hmm.
And the pressure is very significant on the purchasing teams of the buyer company to get the cheapest possible price.
Yes.
For the stuff.
Yes.
You know, and that is a sure way to undermine purpose. So if you have a social or environmental purpose in your corporate governance documents or on your website, or even if you're a social enterprise whose bylaws and charter contain a commitment to advancing a social or environmental purpose, but all the rest of the structure is grounded, rooted in get the cheapest price possible, in all likelihood, your contract will run against your purpose and undercut your efforts to advance your purpose.
And you see that in other relationships. So take the employer-employee relationship. So when employers want to engage with employees, want to lift morale, want to bring employees along on the journey, to really tap into that, into the purpose potential, which is what a lot of the purpose discussion has been around when it comes to employees. You'll really get them super engaged. However, the contractual relationship is still very formulaic. It's very much along the lines of master-servant, the old master-servant relationship. Ultimately, I pay you X sum of money and I own you for the time that you are actually employed by me. And that undermines the employee engagement. So now we come up with different ideas about employee ownership, which is trying to change the dynamics of the legal relationship so that employees are not just employees, but they're also part owners. But if you actually had employment contracts that were far more values-based, that talked about the values of the company and the values of the employee, coming together to create whatever it is that the enterprise wants to create, then you'd actually be talking the same language at the basic level, which governs the relationship, and so on with customers as well.
Yeah. And this is all going to, how contracts can be tools for so much more than just transacting.
Yes.
There are outcomes that contracts can achieve that go far beyond, I'll pay you X number of dollars for X number of hours of your labor, or X number of dollars for X number of widgets, like Y number of widgets. Like the contracts can be much more relational, and in becoming more relational, they can do so much more good. And so the sort of idea behind the Model Contract Clauses Project, the MCCs we call, is in part to sort of, enlist contracts as allies in these efforts to achieve positive social transformation. And this problem of contracts are just thought of as these transactional documents and nothing more, like they're just paper, kind of thing, is common across the board. So it is common in like corporations that don't identify social or environmental purpose as a part of their objective on this planet, and businesses that absolutely do. So all the B certified companies, that absolutely have a purpose incorporated into their DNA, if you will, themselves don't have contracts that match the purpose. And even the United Nations, if you think of a big UN agency, or agency affiliated with the UN, like the World Food Program, if you think about them as like a company, they have a gigantic budget and revenue stream. Like they're like a many $billion business.
Yeah.
But their supply contracts are drafted much like those of any regular for-profit corporation and negotiated in that way, where what you want is you want to get the cheapest price for these goods that you're then going to be giving for free to people in need, right?
Yeah, yeah.
So you have this very clear social purpose, alleviating hunger around the world. You're making this food freely available to people who are starving or on the brink of starvation. Such a laudable, good purpose. But then the supply contracts where you're actually sourcing are rooted in these, close to extractive principles, where it's just like the more I can get for less, the better,
And all of these penalties as well. So it's very punitive. So we're not used to drafting into our contracts, even with the modern slavery example. I've worked with clients who have, encouraged the lawyers, me included, to draft less punitive clauses, because we need to be getting to the root cause. We need to be resolving the root cause, which is to remove the incentives for slavery and to protect the victims, basically to protect the victims. And if you have a punitive modern slavery clause in your supply contract, where you can simply terminate the contract because you found that your supplier is engaging in modern slavery, well, that's not going to help the victim. So we need to draft clauses that are more holistic, that involve working together or working with NGOs, collaborating, all of those principles that lawyers are not used to drafting. So those have to come in. And that's really what you're getting at, that at the front end, really, if you like, at the end, where at the point where you're actually agreeing what you're going to do, it needs to be more relational. And then at the point where something goes wrong because something changes, then that needs to rely on the relationship as well, because otherwise you're not solving any problems. You're just relying on your legal rights, of cutting off the relationship and then allowing that person to operate as they wish.
Mm-hmm, mm-hmm. And we definitely saw a lot of that with the pandemic, right?
Yeah.
Things changed, and many buyers, everything from Western, right, apparel brands to electronics brands to ag brands, changed, used their rights under the contract to exit the contract, do a cut and run, as you say. And then others, like, quintupled the size of their orders, because suddenly now we need so many rubber gloves, know? And so that we have like either a vast, gigantic increase in demand or a precipitous drop, sometimes leading to actual termination of the contract, and without considering, well, what are the human rights impacts going to be of like changing our orders in these ways or changing our contracts in these ways, even if we're allowed to do it under the contract? Is that the responsible thing to do?
Yes.
And so we have in the model, in the version 2.0, we have a very consistent sort of theme throughout the clauses, of which there are 33, which is to follow a shared responsibility model for the human rights performance of the contract. So to step away from a model where, the buyer just kind of gets to call all the shots and put all the responsibility for on the supplier for ensuring that human rights are protected and respected in their factories or what have you, to shift away from that model to one where both buyer and supplier take responsibility at every stage of the contract for its human rights performance. And that includes at the remedies stage. So if one of the things that I think is so powerful about the model contract clauses is that, and this is true of version 1.02, is that it basically says you in earlier contracts, you would breach a supply contract if you supplied like defective goods, right?
Yeah.
Goods that didn't meet like the order specifications of material content, if or design or whatever, something like this. Now we're adding this layer of you can also be in breach if there is a human rights issue, right? So we have what I refer to as like a social breach possibility that really breaks down the distinction between product conformity and production process conformity, right?
Yes.
So you can now be in breach for more things than previously. But one of the things that was not present in version 1.0 is that it said, if there is a social breach, if there is there is an adverse human rights impact that occurs in the environment of the contract, then the following remedies come. And those remedies are all like traditional remedies that basically flow from the supplier, the breaching supplier, to the non-breaching buyer.
Yeah.
Because this is, and mostly it's like money damages, or the buyer has the right to reject the goods that it believes are tainted, or to dispose of them in some other way, but doesn't have an obligation to pay the supplier, right? If they receive defective goods, that's the breach that like terminates the buyer's responsibility to pay for the goods, etc. Those sorts of remedies really don't do the trick when what you're talking about is a social breach or a human rights violation related breach. What you need in those situations is to put human rights remediation first, because you need to target remedies not just between the parties, but to the people who actually experienced the effects of the breach. And that would be, in our case of the MCCs, where we're mostly focused on the workers. So we need to, part of upgrading contracts to be more relational rather than just transactional is to say, in some cases, your remedy for breach has to be directed to victims.
Yeah. And really, you could extend that to environmental breaches.
Yes.
So this
absolutely.
whole concept, the UNGP has actually, the UN Guiding Principles for Business and Human Rights has actually brought in so many concepts that are extremely relevant, extremely useful for this whole idea that all contracts should be relational, because we are all part of a system. So this idea that it's not just that you might cause the social problem or the environmental problem. Are you contributing to it, or are you linked to it? That's actually a very powerful idea, because we're so used to thinking in terms of causation as lawyers. But as soon as you move towards getting to even just being linked to, that goes to the idea of relationship. I'm not responsible for this, but yet I have a relationship with someone who is responsible for it. So just like if you were in a close relationship, say your sibling or your partner did something that was unacceptable or morally wrong, you would be linked to that person. It's the same with this idea of companies. And so in some sense, you have a responsibility, or you have some influence, which is really what that gets at in the UNGP. You have an influence. So it then becomes your responsibility to use that influence, where you can. And I think bringing those sorts of concepts into the contract is where you need a mindset shift.
Totally. Yeah. That idea of like shifting away from a sort of blame model, who is directly causally to be blamed, toward who is responsible in this broader way of not just cause, but also contribute to or linked to through your business relationships is, for me, it is like a total like for how we think about contracts, because it's so not how we think about contracts, so what does it mean to bring that in to the contracts? And our answer to that is I should say, like, one of the things that that we often use to describe the model contract clauses is they're kind of like a Google Translate for the UNGPs into contractual obligations. So we take these ideas of cause, contribute, link to, and we sort of transform them into, or translate them into contractual obligations. And the way that we do that is like in 3 dimensions. One is that we say both buyer and supplier must engage in human rights due diligence.
Yeah.
So not just supplier, and also the difference is usually, and I think the Australian clauses kind of do the usually, which is to say it's just supplier that has to do anything, and supplier usually has to basically warrant or represent that they are in compliance with the buyer's human rights standards, or that they have done the due diligence, as if due diligence is like a one and done thing, which it is not. Human rights due diligence is this ongoing stakeholder involving process, right? Continuous throughout the life of the business, and in our case, throughout the life of the contract, to identify, prevent, and address and report on or account for human rights risks. So in the first thing that we do in the MCCs is say both parties have an obligation to engage in ongoing human rights due diligence. And the second way in which that shared responsibility model appears in the model contract clauses is we say there's a whole section on buyers' responsibilities to engage in responsible purchasing practices, to negotiate a price for the contract that is sufficient to cover the cost of production, and responsible business conduct by the supplier. So at a minimum, to cover the minimum wages under national law, but beyond that is really what we're going for a living wage and responsible business conduct generally. For the buyer to provide reasonable assistance to the supplier in meeting the buyer's own human rights standards. And that assistance can be like training, technological, in kind, or it can actually be money, financial assistance. And for any modifications to the contract to be negotiated and discussed with the supplier, to give the supplier a chance to say, actually, I can't meet your tripled order unless you give me more time or more money per unit so that I can pay my workers overtime. Like to actually create room for conversation and negotiation. And the last one is to engage in responsible exits, So like, don't just leave your supplier the moment that something that you don't like happens, and pay any outstanding invoices that you have before you leave. Because one of the terrible things that happened with COVID is a whole bunch of brands abandoned their contracts and didn't pay for the orders, even orders that were like completely manufactured and had shipped. So, and then the third area where the shared responsibility comes in is remediation, which says that, if you have a social breach or a human rights issue that arises in the environment of the contract, both the supplier has to prepare a remediation plan to address the grievances of the victims. And if the buyer somehow caused or contributed to the harm, then the buyer also has to participate in providing remedy to the victims, which is
it's fundamental
completely,
to the UNGPs.
It's fundamental to the UNGPs, and it's a total departure from how we normally think about contract remedies.
Yeah.
And then we have the more typical contract remedies around like rejection of the goods and indemnification and so on. But those only come after human rights remediation.
Yeah.
So we flip the order all to be in line with this shared responsibility idea that the UNGPs that enshrine for us.
So it strikes me that as I'm hearing you explain what these model contract clauses are and how they translate the UNGPs into actual contractual speak, it strikes me that you are really pulling together various parts of law and parts of the whole purpose debate that I've been working in. So modern slavery, for example, balancing profit with purpose is another. And the third is contracts. So we were introduced through Kim Wright, and I've been thinking of signing up to Kim's Conscious Contracts course so that I can learn to do what she calls conscious contracts, which are value-based, relational-based contracts, and which deal with embedding the values of enshrining the values of the two parties, plus adjusting to any changes. So what happens when circumstances change, and reducing conflict when that happens. So what I'm seeing is that, so insofar as the contracts work that I'm focusing on, the connection with what your work is, I'm seeing that it's taking that contract idea of the parties as being largely smaller enterprises or individuals, to really extending it up, scaling it up to much larger companies. Because even with the B Corp experience, it's been the same thing. Once you scale up to a very large company with entrenched behaviors, with large legal departments, with a general counsel who may be very resistant to these ideas, you have a lot of cultural change. But what your clauses, I'm getting the sense, is what your clauses do is they are entirely customizable, from small scale right up to the larger scale, and written in language that the larger companies can absolutely adopt.
Yeah, they're drafted to be used by any company of any size from any industry.
Yeah.
And they are designed to be modular. So even in the document itself, we offer different options. So you can choose different options for your clause, but those are just suggestions. You can edit however you see fit.
Yeah.
So it's definitely not you have to take all 33 clauses as they are type of exercise. It's really, the idea is that the MCCs provide a kind of menu of ways in which contract drafters can enlist their contract as an ally in supporting their purpose. And it invites, right, a certain introspection. What do we want? How far do we want to go? How far do we want to align our legal life with our stated purpose? And we know that to adjust our contracts in this way is going to have an impact on budget and operations and all this kind of stuff. Let's talk about it. How much are we ready to really bring coherence in? And so it's absolutely scalable. But you also started saying something that made me think about. Oh yeah, I suppose the other thing that's happening, the MCCs are kind of a part of, is not just the normalization of the UNGPs and these ideas of cause or contribute, but also bringing in a more stakeholder based approach into again, the operational and legal life of the corporation, and using the contract as a way to, fully make the DNA of the company shift away from a singular focus on shareholder wealth, right?
Yeah, which brings me to a question about the response you've had, because I would love to see. We have a task force in Australia around the modern slavery work, who are advisors to the government. I would love to see them look at your MCCs, and I think it would be easy enough to bring it to their attention, because I know people who are on it, and use some of your ideas in what's suggested to Australian businesses and reporting entities. What has been the response that you've observed to these MCCs, these model contract clauses?
So it still feels pretty early days in terms of launching. We're having like conversations with different groups of folks. So there's conversations happening one-on-one with companies, and conversations happening with like industry associations, because industry associations are a really good, interesting way to sort of not just spread the word, but like kind of change, like identify best practices that every company can then look at. So there's advantages to going company by company, but there's also advantages to going to an industry association level or a multi-stakeholder initiative level, where all the companies are looking to that entity for guidance. And we're also talking to some regulators, and we're talking to certification schemes and different kinds of like private ordering and public ordering bodies. And by and large, like also the OECD, like a number of, we also had like our consultations to draft version 2.0 were very extensive. We talked with over 70 people from various industries and walks of regulatory life, private and public ordering folks. The reception has been by and large very positive. Like there's a lot of like immediate resonance of the idea of like, it doesn't make sense and it doesn't work to put all the responsibility on the buyer. Yeah. Like just, on the supplier. Like even like morality aside, it doesn't work. Like when you put these reps and warranty systems in where you're just saying supplier warrants that no problems ever in the supply, it's basically just like getting a stamp on something that isn't true. So it doesn't serve any purpose. It doesn't work for anybody. So people are really more and more responsive, feel very responsive to the idea that that system needs to be set aside in favor of what? Well, the shared responsibility model also makes a lot of sense to people. The idea that purchasing practices are a part of the problem is, I think, used to be a very foreign idea and is increasingly becoming like an accepted part of the, like an understood part of the puzzle of human rights and supply chains, if you will. And so then when we come in and say, well, if you can go that far to realize that how the buyer behaves matters, then you might be interested in these model contract clauses, and people are generally like very interested, and also understand how their contracts are an integral part of their corporate social responsibility. I think there is, like, as I'm sure you've seen, tends to be quite a separation, silos within corporations between the CSR or ethical trading or sustainability folks on the one hand, the legal folks on the other, and the purchasing team on the other still. Yeah. And what we've, and what has ended up happening is sometimes we get to speak to the legal folks first, but what often happens is we come in through the CSR people, and then we talk to them about the contracts, and they're super psyched because they're like, oh, you've given me tools to talk to my legal team with.
Yeah.
Because often those CSR people are not lawyers, right? Yeah. So to give them tools, that feels really exciting, and it's part of the whole coherence work that the MCCs can do. So yeah, very positive reception. In terms of like actual uptake, we know that like various law firms are using the MCCs as like part of their client alerts, or saying like, look, the EU is developing this mandatory human rights due diligence legislation. Germany already has one. France already has one. More are on the way. The EU directive specifically references contract clauses, specifically says you should have contract clauses that support your human rights or environmental due diligence strategy. So we're seeing law firms point to the MCCs as being like, this could be a way to meet that legal requirement. So yeah, the idea is getting a warm reception. I think people are excited to rethink their contracts and include that rethinking as part of a certain kind of introspection. Yeah. Companies that are already committed, like B Corps, are going to hopefully be especially
I would
keen.
think so, yes.
But then you also have the other companies that I think about as like, so like the B Corps I think of as like natural allies, and then there's the other companies that I think of as CYA companies that are like just concerned about evolving legislation and how to keep in step with it.
They look very much to what everyone else is doing, so they don't want to go first. Yeah, but that's why the industry associations will be very helpful.
Exactly, yes.
Yeah, well, that sounds very promising, Sarah. This has been an excellent, eye-opening, educational episode. So I am really, I want to congratulate you on the MCCs and the work that you're doing. I think it's going to take off in a big way.
Oh my gosh, I really hope so. And, the group, 'cause it's obviously not just me, the working group is full of like-minded folks who are all incredible, and it's been such an honor and an exciting opportunity to participate in this work. It feels really it feels like a really nice way to bring my academic and my practical work in line with my own personal values, to bring some coherence into my own experience of being an alive lawyer person. And so thank you so much for giving me the opportunity to share this with you.
Thank you.